people are in compliance, and if they're not, then you send them a letter.
So you can prove yourself in or state your.
That's what I think.
That's what I'm telling you.
But then like, what do you do? Like, how do you fill your 10-hour days?
I don't.
Oh, yeah, I know. I know all about that. Right, Josh?
So you two are short timers. You're sitting-
Don't look at me.
Not you.
I'm
You're sitting between
here
a
for
couple
the,
of short
I know, that's why I have to sit here. Today's Josh's last day for a year.
I think we should do something nice for him.
Can we like start off with the Pledge of Allegiance?
He's gonna be doing that every day. Jeez, give me a break. How about?
Do you want to like say any a few words before we start?
No, I'm good.
Let's give him passive sexual abuse.
Oh, trust me, this morning I was already like, I'm gonna let that one go because today's your last day. Yeah.
You already gave you the pass.
And that was appreciated.
And that was, yeah. Yeah. I appreciated it.
No, yeah, I don't know, did you?
I wasn't sure if that's okay. Like, I don't know. Yeah. I know. Well, it's, I'm fine with it.
Yeah, right.
Yeah.
Until then.
Yeah, I know.
I mean, I'm just trying to figure out the new lay of the land. For old people, it's kind of
Confusing.
Well,
I mean, I'm not with
You always
these guys
expected
who
when you
like
got
people
to
in
be,
their hotel rooms.
you always expected when you got to be this age, you could get away with a lot more shit.
Exactly, yeah. I mean, my
Like college
dad
kids,
always
like-
reviewed all the women as cute little things and stuff like that. He got away with it.
absolutely. You know, and go to a meeting and be like, well, darling, you know. I
Yeah,
mean,
darling, exactly, darling. Come on over here,
Yeah.
sweetheart.
But see,
Sit
that-
like me.
yeah. Well, yeah.
I already tried. It didn't get anywhere with the man this morning.
Guys.
She's not persuaded.
No. Well,
She's smarter.
yeah. Well, we
Hello,
might need to
darling.
Skype you in for a deposition, Josh.
If we did January.
I don't think we're doing this.
You're not gonna Skype in for?
No.
He's gonna be flying jets around.
When is the group over here?
Next week.
It is the first week of
It is next week.
Are you flying that day, Josh? Did you do like a flyover?
Yeah, do you want me to drop anything?
Maybe.
Yes. Yes, the candy bomber.
Like
Candy.
some revelation? You want me to drop some?
There'll be plenty of that, I'm sure. You don't need any more.
So what's happening here?
I guess we're waiting for the fire alarm to clear, huh?
They're seeing if they can find an alternate location.
That's like a really long fire alarm.
Well, fires don't put themselves out, Ollie.
Well,
They do here?
Yeah.
absolutely.
All you have to do is gather in the parking lot and they're gone.
Yeah. Touch my knee.
I witnessed it.
Josh, I know, you are my witness.
I'm here again, I'm just, I'm always nothing.
Hey,
Wow.
Dustin's always there.
I'm there. So I'm not a very good witness. I did see it. Yeah, I was there.
Can I get a,
I'm your witness, Brad, don't worry.
whatever.
Somebody be the attorney for John. Steve's the attorney for the division.
Yeah, Emma was gonna do.
We're just trying to figure out.
I want to kind of write something that's funny in like
I don't think they're
Sid and Robin's cards
You might not be doing it either.
anonymously.
Yeah.
I see your card.
sitting here.
Why don't we just go
Process.
release some? All we gotta do
Just
is-
smear them on the.
As soon as we walk out of the room. Well, here's the plan. We'll just go back to work. And if they get it up and going, we'll give you a call. If not, we'll,
Do we need to tell YouTube the plan?
We're gonna update, we're broadcasting right now, so anyone that goes to YouTube, if you tune into that, well, YouTube is always 2-3 minutes behind right now, but
Okay.
we will keep that updated until we reconvene or
Keep
adjourn.
this on it, or?
Yeah, that screen off on the right that says we're suspended, that's what's going to the public right now.
Okay.
So that can be monitored.
Like the
I'm just gonna sit there.
oh, okay, this is real.
Yeah, we're trying to be completely transparent.
usually things go a lot smoother than this.
This is the first.
Did Marcy not answer?
No, voicemail, which
Come back at
I'm just
11.
gonna hang out.
Yeah, I mean,
Random.
you guys, I mean, we could be
I don't
here.
even know what I work in.
Wait, Josh
I was
doesn't
just
even
saying,
work.
I don't even know what I do here, so.
Nothing.
That would imply that
What
we
am I
were
doing
already
here?
I,
So we're gonna meet here at 11?
No, we'll just say, he'll stay here. If it comes on.
I'll stay here, yeah, I'm
If it
tied
comes
to
on-
this.
That'll be scheduled, so as soon as it comes on, he'll contact
If
us.
it does.
Yeah, we'll,
Don't go to lunch yet, Steve.
Yeah.
do
Keep your
not
beeper on.
go to lunch.
we'll send an
Dang.
email out at 11 o'clock updating status.
Okay.
It's cutting into our plans.
Yes, you are.
We just won't come back.
Sorry that you're not gonna join us, Dustin.
What are your plans?
We have a sayonara. The shake,
I
shake,
wasn't
shake,
invited.
Djibouti. What? Well, that was
Talk to
Dane's.
Dane, Dane was the one in
Dane.
charge of that.
Yeah,
Dane's in charge.
That dang dang.
I know. Dang it, Dane. Way to drop the ball.
Didn't even invite your boss, huh?
Oh, now he's like, I am the boss.
Alicia asked me if she was reporting to you, and I told her yes.
You're really scared.
I drank it.
Yeah. So they're more or less removals.
Denver, can you hear us okay at this point?
Yes.
Okay, thank you. Denver, can you hear us okay at this point?
Yes.
Okay, thank you. Denver, can you hear us okay at this point?
Yes.
Okay, thank you.
We got her.
Denver, can you hear us okay? Okay, thank you.
Yeah. No, but you don't have to be able to see Coco. Sure. Shake the balls to that.
Are we ready?
Tense with the white wall behind us.
I know, we need some like a
They look
green
very
screen.
serious.
We need some sort of, we should come
Photo
here and
shoot
paint
or
this.
something,
I don't even like the look of that.
Huh?
I don't like to see myself up there.
No.
I just focus over here. Good to go? Good morning. Can you hear me in Denver?
Yeah, good.
Okay, good. We're glad you're safe and sound. All's well there?
All's good.
Okay, good. Well, we'll proceed. Appreciate those that got us back up and going again. Thank you, Paul, Tom. My name is John Rogers. I'm the Associate Director of the Division of Oil, Gas, and Mining, and I've been asked by the Board of the Division of Oil, Gas, and Mining to act as a hearing officer in this matter. We are gathered today at the Department of Natural Resource Building in Salt Lake City. Today is November 28, 2017. We will be hearing the matter, docket number 2017-029, cause number 139-152. It's a matter of request for AXIA 2, LLC, for order pooling all interests, including compulsory pooling of the interests of certain non-consenting and unlocatable owners within 4 1280-acre drilling units, which occurs for 5 wells established for the production of oil, gas, and associated hydrocarbons from the Lower Green River-Wasatch, Colton formations, comprised of all sections of 26 and 35 and 27 and 34, Township 2 South, Range 1 West, Uintah Special Meridian, Uintah and Duchesne Counties, and Section 26 and 35 and 27 and 34 of Township 2 South, Range 2 West, Uintah Special Meridian, Duchesne County, Utah. At this time, we'd like to take appearance of counsel.
David Bolda with Beatty and Wozniak on behalf of AXIA Energy 2 LLC.
Steve Alder, Utah Attorney General's Office, on behalf of the Utah Division of Oil, Gas, and Mining.
Meg Oswald, Utah Attorney General's Office, on behalf of the hearing examiner.
Okay, thank you. And I'd just like to go on record to recognize that all witnesses are being, for AXIA will be heard over the internet on the video conferencing. So, David, we'll turn the time over for the presentation.
Okay, thank you. I'd first like to introduce my witnesses. We have Leslie Gadd, who appears on the left side of the screen, who is a contract landman for AXIA, and Taryn Frenzel, who is the Vice President of Completions and Engineering, on the right side of the screen. I'd like to ask at this time that the both witnesses be sworn in.
Could you raise your right hands, please? There we go.
You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. I'd like to point out that Mr. Rick Gallegos was originally scheduled to testify at the hearing today. He had a conflict that arose at the last minute. And so Leslie Gadd is sitting in his place. I filed a motion yesterday with her statement of qualifications. And previously filed had been Mr. Frenzel's statement of qualifications. But they've been submitted as Exhibit A in this cause. I will, when we get to Mr. Frenzel's testimony, I might ask that he be admitted as an expert in petroleum engineering, but we'll wait until his testimony.
Are you planning to have Leslie Gadd?
Not as an expert witness,
Okay.
as a fact witness. Now I'd like to give a summary of this case. So for drilling purposes, subject sections 26 and 35 of Township 2 South, Range 1 West were established as 1,280 acre drilling units in cause number 139-143, which was entered on June 9th, 2017. And this was for Lower Green River-Wasatch production. Both sections 26 and 35 are regular governmental sections totaling 1,280 acre drilling units. Sections 27 and 34, also of Township 2 South, 1 West, were established as 1,280 acre drilling units in cause number 139-138. That order was entered on July 18th, 2016, also for production from the Lower Green River-Wasatch formations. Those are also regular governmental sections totaling 1,280 acres. Sections 26 and 35 and 27 and 34 of Township 2 South, Range 2 West were also established as 1,280 acre drilling units. Those were done in cause number 139-140, which was entered on January 23rd, 2017. And modified by the order on rehearing for modification entered on April 4th, 2017. All four of those sections are regular governmental sections, together each totaling 1,280 acre drilling units. True and correct copies of those spacing orders 139-143, 139-140, and 139-138 were submitted as Exhibit B. As Mr. Rogers mentioned, there are a total of 5 wells within those 4 drilling and spacing units that are at issue today. The first of which AXIA planned to plans to drill a long lateral horizontal stand-up well upon sections 26 and 35 of Township 2 South, Range 1 West. That's the Butcher Butte 35-24H-21 well. The majority of the lands in that drilling and spacing unit, which we've designated as DU-1, are fee lands with some scattered, partially owned BLM tracts. Description of the tracts and ownership types were submitted with the request as Exhibit 6, which we'll address in greater detail later. AXIA has not yet spud this well. In accordance with the 139-138 order, AXIA plans to drill an additional long lateral horizontal well upon sections 27 and 34 of Township 2 South, Range 1 West. That is the Butcher Butte 34-94H-21 well. The majority of the lands in this drilling and spacing unit, designated as DU-2, are fee lands with some scattered city-owned lands, City of Roosevelt, some county and state-owned tracts. The description of the tracts, which will be addressed later, were submitted as Exhibit 7. AXIA has not yet spud this well either. And in accordance with the 139-140 order, AXIA planned to drill 3 long lateral horizontal stand-up wells, 2 upon sections 26 and 35 of Township 2 South, Range 2 West. That is the Butcher Butte 35-44H-22 well, and the Butcher Butte 35-54H-22 well. And that is in the drilling and spacing unit designated as DU-3. The final well is located in sections 27 and 34 of 2
Excuse
South.
me, Dave.
Yeah.
You did not mention the land ownership there. You did on the other.
I will get to that after I address this well.
Okay.
All the lands involved here are primarily owned in fee with a couple of scattered tracts. In DU3, there is 1 state-owned tract. The rest are all fee, and in DU4, they are all fee. Okay. The well upon sections 27 and 34 of 2 South, 2 West is designated as the Butcher Butte 34-144H-22 well. Again, a description of those tracts and the ownership type. They were submitted as Exhibits 8 and 9. They'll be addressed in Ms. Gadd's testimony. AXIA has spud the surface holes for all 3 of these wells. The first 2 were spud on September 5th of this year, and the third well in this that we just described was spud on September 6th. First production hasn't been achieved yet for any of those wells. Even though we're dealing with a large area here and a lot of owners, there's a very limited amount of interest that we're asking to be compulsory pooled in this hearing. Within DU1, at this time, there are only 2 that have not agreed to lease or participate. Within DU2, there's approximately 8, and some of those owners are unlocatable. Within DU3, there are 4 owners, all working interest owners, who haven't agreed to participate or have agreed and haven't yet signed a JOA and tendered their proportionate share of AFE costs. And in DU-4, there are only 2 that haven't agreed to participate. Again, those are both working interest owners. There are also a few estates of deceased parties for whom forced pooling is sought. As will be discussed during the testimony of Ms. Gadd, AXIA diligently searched for the potential heirs of these deceased parties. They obtained leases where heirs could be located. And however, until those estates are probated and an order is entered determining the heirs and distributing the property, there's no way to definitively determine who all the heirs are. And so even though in some cases we think all those heirs might be leased, we still have to include those estates in case additional heirs are discovered. In many cases before official offer letters were sent out to the various owners to participate in the subject wells, AXIA commenced efforts to locate and lease the owners within the subject sections. Official offer letters to lease or participate were sent in August or September of this year via certified mail. AXIA has continued to work with and negotiate with any of the parties willing to lease their interest or participate in the subject wells throughout this process, even after filing the request. This is illustrated by some of by the motion filed yesterday and some of the exhibits where some additional parties were leased, and a working interest owner agreed to participate and signed a JOA. Now we'll address that during the hearing as well, during the testimony. Since there are a few scattered BLM tracts in DU-1, communitization agreement will be required, which cannot be approved until compulsory pooling order is entered. I want to address a couple of the regulatory requirements that AXIA must meet in order to have their request granted. Utah Code Annotated Section 40-6-2-11 defines a non-consenting owner as an owner who, after written notice, does not consent in advance to the drilling and operation of a well or agree to bear his proportionate share of the costs. Utah Administrative Code Rule R641-2-9 subsection 1 provides that an owner shall be deemed to have refused to agree to bear his proportionate share of the costs of drilling and operation of a well if, excuse me, if the operator has in good faith attempted to reach agreement with such owner for the leasing of the owner's mineral interests or for that owner's voluntary participation in the drilling of the well, and the owner and operator have been unable to agree upon terms for the leasing of the owner's interest or for the owner's participation in the drilling of the well. We believe that the testimony and evidence presented today will establish that the regulatory and statutory requirements to deem the unleased and uncommitted working interest owners, which were described as the non-consenting FP parties in the request, as non-consenting parties and to compulsory pool their respective interest as to these 5 subject wells and their associated drilling units. We believe those requirements will be satisfied or demonstrated to have been satisfied through the testimony today. Utah Code Annotated Section 40-6-6.5 sets forth all of the terms and conditions to be considered and imposed by the board in a compulsory pooling hearing and order. In the interest of brevity, I won't reiterate all those here. However, there are a couple of these terms and conditions I do want to initially point out. First, the board can impose a risk compensation factor, which is commonly known as a non-consent penalty, of no less than 150%, no more than 400%. In this case, AXIA has asked for a 300% non-consent penalty. The testimony today will establish the circumstances involving these wells and justify imposition of a 300% penalty. Second, the statute authorizes the board to impose the terms of a joint operating agreement upon compulsory pooled parties to govern operations as long as those terms are fair and reasonable. AXIA has requested the board to adopt a joint operating agreement. Even though there are 5 wells, one joint operating agreement was submitted with the consent of the division so that there weren't 5 JOAs all containing the same terms. Only one was submitted, and that was submitted as Exhibit H. The testimony will establish that the JOA contains fair and reasonable terms. The board has jurisdiction over this matter pursuant to Utah Code Annotated 40-6-6.5. That authority has been granted to the hearing examiner in this cause. A copy of the request was mailed by certified mail to all the interested parties within the subject sections and to the governmental agencies having supervisory jurisdiction. As evidenced by the return receipts, which were collectively submitted as Exhibit ZZZ yesterday, nearly all identifiable, locatable parties received a copy of the request. There's only one party that did not receive a copy of the request. His mailing was returned. Interestingly, this individual, his name is Grant Cook. He received a copy of the lease and the offer to participate. When that was sent out, he signed the return receipt. For some reason, this copy of the request was returned to us. As to those parties who could not be located because no current or valid address could be found or are potential heirs or devisees of the estates of deceased parties, notice was published in the Uintah Basin Standard and the Vernal Express and UtahLegals.com. This is indicated on the affidavit of publication, which is marked as Exhibit YYY, also submitted yesterday. However, it's been submitted as Part 1 of 2. That affidavit is from the Uintah Basin Standard. Even though we also had this published in the Vernal Express, for some reason we haven't yet received their affidavit of publication. I assume it's because of the holidays. They weren't able to get it in time, but as soon as we receive that, we will file that Part 2 of 2. Notice of the request in this hearing was also duly published in the Salt Lake Tribune and Deseret Morning News on November 5th, 2017, and in the Uintah Basin Standard and Vernal Express on November 7th, 2017. Only one response to the request was received, and that was from a Mr. Evan Gentile. We will discuss sort of that interest and where that comes from. He's a purported heir, or his wife and in-laws are purported heirs of the Wilkins. No other responses were received from any notice parties, and the division did not file a staff memorandum in this cause. And that's it for my summary. At this time, I would like to go to my first witness and ask Ms. Gadd, can you please state your name and business address for the record?
Leslie Gadd, and the address is 1805 Shea Center Drive, Suite 400, Highlands Ranch, Colorado, 80129.
And your current position with AXIA?
I'm a contract landman working directly under Rick Gallegos.
And you have responsibilities in AXIA's Uintah Basin assets, inclusive of the lands at issue today, correct?
Correct.
Thank you.
I did not get the exhibit that you filed yesterday with her background, her qualifications, and I also didn't catch how she spells her last name.
I'm sorry. Would you like me to do that?
Yeah, spell your last name, please.
It's Gadd, Gadd.
It's also up on the screen.
Yeah, go ahead.
We good? Okay. I'll I'll have Mr. Frenzel address AXIA's corporate and bonding status, since he's an employee of AXIA, so we'll save that for his portion of the testimony. At this time, I would like to turn to Exhibit C. Again, Exhibit A is up on the board. That's the statement of qualifications for Ms. Gadd and Mr. Frenzel. Exhibit B, again, was the spacing orders. I don't have them up here. I think all of them together are close to 80 pages, so we won't go through those at this time. Ms. Gadd, can you please, or let me ask you first, were these prepared by you and with input and review from AXIA personnel?
Yes.
Okay, can you please explain what Exhibit C shows?
Yeah, Exhibit C is showing all of the lands involved in the 4 drilling units that we're requesting, as well as the 5 well locations of each one of the wells. In the one, there's 2 wells in the 1 drilling unit.
Okay, thank you. At this time, I would like you to turn to Exhibits D, E, F, and G, and Exhibits 6, 7, 8, and 9. Those Exhibits 6, 7, 8, and 9 are exhibits to the request, and ask, were those prepared by you with input and review from AXIA personnel?
Yes.
Okay. Let's turn now to Exhibit D and Exhibit 6, which we will get to at that part of your testimony. Can you please explain these 2 exhibits, Exhibits D and Exhibit 6, to the request?
Yes. Exhibit D is showing all the different tracts within the drilling unit that represent different ownership under each one of those tracts. And Exhibit 6...
before Exhibit 6, can the second page of Exhibit D?
Sure, that is the survey that was done showing the surface location of our well and the target bottom hole location. It's up there on the north end.
Thank you.
For the Butcher Butte 3524H21 well.
Okay, and now Exhibit 6.
Mr. Rogers, if I might, just to avoid asking questions after the fact, I'd like a little more background about Ms. Gadd's participation in these exhibits and their preparation, what she does besides assist Mr. Gallegos. More specific, please.
So I review all of these title opinions. I have looked at all the ownerships. I have put together working interests, net revenue interests. This map, I identified all of the tracts based on the title opinion, the acreage, the ownership, whether there was any BLM lands, state lands, county lands. Obviously, I didn't do the survey that's attached to that, but I have 37 years experience in oil and gas and land work, identifying owners, ownership, tract participation factors, identifying working interest owners, mineral owners.
Thank you. I just thought the general statement that you assisted Mr. Gallegos was a little brief. Thank you.
Sure.
Okay, now to Exhibit 6.
Okay. So Exhibit 6 is showing each one of the tracts with a legal description, the gross acres that each tract contributes to the 1,280 acre drilling unit, the percent of that each tract within the unit, and the ownership, whether it's fee or in this case fee and BLM for tract 1, and then tract 2 again, fee and BLM. Most all of those were the BLM owned a 50% mineral interest, the rest was owned fee. And then at the end, you see the total of the 1,280 acres that make up the unit.
Okay, thank you. Let's go now to Exhibit E and Exhibit 7. Can you explain these exhibits?
Okay. Again, Exhibit E is showing all of the different tracts based on title opinions that we got, which are from the county records, ownership records, showing each tract with a different ownership and their acreage that contributes to the full 1280. Along with, attached to that is the survey again of the well, the Butcher Butte 3494H21 well, and the surface location and our target bottom hole location.
And I want to clarify for the division that the Exhibit 7, just like Exhibit 6, was an exhibit attached to the request that identifies the tracks. We had them identified in the request.
Thank you.
Mm-hmm. So Exhibit 7 is on the screen now.
All right. So Exhibit 7, like the last one, is all the tracts, the section that the tracts are located in, the legal descriptions, the gross acreage for that tract, the percent that tract contributes to the total unit acreage, and again, the ownership. And you can see there on page 2, there's that City of Roosevelt, Tract 17, State Tract 18, and Tract 22 is the Uintah County tract.
Thank you. We'll turn now to Exhibits F and Exhibit 8 to the request. And again, if you could explain these exhibits.
All right. This Exhibit F is representing sections 26 and 35 and 2 south, 2 west, and the different ownerships in each of the different tracts within that 1280. And then the survey attached shows the surface location of the Butcher Butte 3544H22 well and our bottom hole location. And then there's another survey attached to this one because we have 2 wells in this drilling unit that we're proposing. And the second well is the Butcher Butte 3554H22. And then Exhibit 8 is, again, all the tracts that contributed to the 1,280 acre drilling unit. The sections located in, the legal descriptions, the gross acreage that each tract contributes to the whole, the percent of each tract within the unit, and again, the ownership. For example, Tract 2 is a state lease. The rest are all fee leases.
Mr. Boulder, I'd like to just point a clarification here. When you say ownership is fee, does that mean that's all owned by one fee owner, one person, or there's several people in there in that fee ownership?
There may be 100 people in one acre tract. I mean, no, it does not mean that it's a single ownership. It just means that all of the mineral owners within that tract are fee owners, whether it's one lease or 100 leases.
Thank you.
Mm-hmm.
And turning now to Exhibit G and Exhibit 9 to the request, can you explain these exhibits, please?
Exhibit G is representing sections 27 and 34, 2 south, 2 west, and the different tracts where we have different ownership and the acreage in each tract. And then, excuse me, the survey attached is showing the well location, surface location, bottom hole location, for the Butcher Butte 34144H22 well. Then Exhibit G is showing each tract, the section in which they're in, the legal description for each one of those tracts, the gross acres contributing to the unit, the percent of each tract in the unit, and the ownership. Again, all of this is fee.
Okay, thank you. I'd now like to discuss the leasing status and the offers to lease or participate from AXIA. Before we cover the exhibits, and you mentioned this before, but I want to point out how were the tracts determined and the individual ownership within the subject sections determined?
So we have the county records are checked to determine who owns the minerals and the surface, for that matter. And that information is composed with title attorneys in a title opinion that's then submitted to us. And so that is how we determine who we need to contact and who owns what. The title attorney that sets out the tracts, the tract numbers and the legal descriptions with the acreage.
Okay, thank you. I'd now like you to, Leslie, to please look at, and we'll go over each of these exhibits individually, but if you'll please look at Second Amended Exhibit 1, Third Amended Exhibit 2, and Exhibits 3, 4, and 5. These are all exhibits to the request. Second Amended Exhibit 1 and Third Amended Exhibit 2 were submitted with a motion yesterday. And Leslie, were these prepared by you with input and review from AXIA personnel?
Yes.
Okay, thank you. We will turn first to Second Amended Exhibit 1 to the request. Now, can you explain these exhibits for us, and we'll go through each one, starting with Second Amended Exhibit 1.
Yes, these are the working interest owners that are in the well that have not either made an election or have not yet signed a JOA. Or they are unleased interests that we are still trying to either contact or negotiate with to either get them leased or to participate.
Okay. And so the amended Exhibit 1 to the request was previously filed, as I mentioned. Second Amended Exhibit 1 was filed with a motion yesterday to replace this exhibit. And that is because a party who was originally included in the request has since leased their interest. Isn't that correct?
Yes.
Okay, thank you. So that party has been removed from Second Amended Exhibit 1 and we're no longer seeking to pool that interest in this hearing. Turning now to Third Amended Exhibit 2. Again, this was submitted with the motion yesterday. The need to submit this Third Amended Exhibit 2 was because a party was removed. And that was in Second Amended Exhibit 1. It included the John D. Chasel as trustee of the John Chasel Family Revocable Trust. AXIA has since been able to get an agreement with that working interest owner, and so that party has now been removed, and that's why this Third Amended one was filed. Can you please explain this exhibit to everybody here?
Yes, this exhibit is also all the working interest owners who have either elected to participate or not, and not signed a joint operating agreement, or who are unleased interests that we have tried to find or we haven't yet finalized negotiations with them.
And on page 2 of this exhibit, it includes the unknown heirs of G. Paul Wilkin and Betty Wilkin, and then in parentheses, excluding Paula Deller, Ivan Wilkin, Shirley Gentile, and Arbetta White, and their respective spouses. Can you explain this interest here, why we still have the unknown heirs listed, even though some of these individuals who claim to be all the heirs of the Wilkins are still, why we still have this interest listed?
Sure. So our title opinion came through showing G. Paul and Betty as the owner of this mineral interest. So I found an address for them and sent a certified letter off to them offering to either let them participate or lease or sell to us, and it came back as undeliverable. So I then did some more research and determined that G. Paul had died some years ago, and Betty had passed just 2 years ago in 2015. And I was fortunate enough to find obituaries that listed the children's names, and there were 4 names listed that David had just read off. So then I again tried to find addresses for all of those 4. As it turns out, I only had one good address of those 4, and that was Paula Deller. So she did get the letter, and that's what kind of started the ball rolling, where Evan Gentile ended up calling me, and we had a long discussion about that. And then, as it turns out, they decided to lease with John D. Chasel Revocable Trust, I think it was. And I just talked to him yesterday, and John has signed the JOA and has elected to participate in a well. That was yesterday.
Great. And so we, in this request and on this exhibit, we're not asking that the interests of those 4 identified heirs, the heirs that Mr. Gentile included in his letter, we're not asking that those 4 heirs their interests or leases be compulsory pooled. Only any unknown heirs, if any, are discovered during the probate process, correct?
Correct. There's nothing at all of record that even indicated either one of them had passed. There's no probate for either one of them. So we have absolutely no way to identify that these are the only 4 heirs.
Correct. Okay, thank you.
We're just a moment. We're still a little confused on this whole transfer. Now, do the heirs of the Wilkins have any royalty interest, or are they leased 100% to the Chasel Trust?
So they have leased, so those 4 heirs that he identified, there's 4 siblings and then their spouses. Those 4 have leased to the Chasel Trust. So they leased all their interest, and Mr. Gentile claims that those are the only 4 heirs of the Wilkins, which may very well be the case. But until they go...
You're not sure. There may be others.
Until they go through the probate process and there's a final order entered by the court, we don't know if some other heir could come forward and say, no, wait, I'm a child of this person as well. I should receive an interest.
But what I'm confused with is I read through here that one of these heirs did sign with AXIA, I thought.
No, none of these 4 heirs. They had negotiated with AXIA, which is what Ms. Gadd just explained. They had negotiated with them and then decided to lease with the Chasel Trust.
So any royalty they receive will be from the Chasels. They don't have any royalty interest left.
Right, their royalty is described in the lease,
okay.
Which has now been voluntarily pooled by Mr. Chasel, okay. And so they'll receive their normal royalty interest on their share of the production, provided what will happen is an update to the title opinion will be done, and it'll state that there's these additional 4 leases who claim to be heirs. And the title attorney will state that interest needs to be held in suspense until there's a final order, so you know that, yes, those are all the heirs.
Okay, thank you.
I guess that answers my question. My question was more, are they being paid as if they own the entire interest? But it sounds like that's yet to be determined.
Yeah, there's no production on these lands yet, so nobody's being paid on any production.
Will they be eventually treated as if they own the entire interest, or?
So AXIA is willing to treat those as valid leases, even though the succession of the interest from G. Paul and Betty Wilkin has not yet been determined. So once they have their probate done, and there's an order from the court saying, yes, these are the only 4 heirs. They each received, say, 25% of their parents' interest. Then that money will be released. They'll be held in an account until they get their probate done, which is common in all title opinions in cases where an estate hasn't been probated.
Can I interject something here that might help? Evan Gentile told me that the family has hired an attorney to start the probate proceedings. Evan is a longtime oil and gas person, so he knows all about this, and they are getting the probate worked on now so that they can furnish us with that information to assure us that we are paying the proper heirs, which are the 4 children, and that there is no one else that would make a claim against the estate through the probate. That we don't know. But he's staying in touch with me on all of this.
Okay.
Okay, thank you. That clears it up.
Okay.
A little confusing.
No problem. Now, exhibits 3 and 4. Can you explain these 2 exhibits?
Yes, exhibits 3 and 4 again are the working interest owners that have either elected to participate or not participate and that have not signed a JOA yet on both of these. And in both of these, 3 and 4, we don't have any unleased interests out here. We don't have any unidentifiable people or unlocatable people on these for these working interests.
And so we, because there are no unleased interests, there's no need to submit the average royalty rate because there's no mineral interest owners that would receive that. They have all been leased, correct?
Correct.
However, there are, as you mentioned, there are parties, working interest owners who are the lessees of certain individuals who have either not made an election or have made an election not to participate or elected to participate but haven't yet tendered their AFE costs or signed a JOA, correct?
Correct.
And those parties need to be pooled
Correct.
to include those leases within the unit, correct?
Correct.
Thank you.
Can I just get that clarified, because this is somewhat confusing. You're saying all parties have been leased, but some have chosen not to participate. Now, if they choose not to participate, then aren't they just being force pulled as a leaseholder? I mean, I don't understand what you're saying.
Yes,
You're trying to force pull a working interest owner.
The leaseholder, the lessee or the owner of the lease, not the person who signed the lease, the individual mineral interest owner, is referred to as a lessee or a working interest owner. So those could be interchangeable. So in this case, you take on Exhibit 3, Newfield Production Company. They have obtained leases from certain individuals and within this drilling and spacing unit, and they received the offer letter to participate from AXIA, but they have elected to not participate in either of the wells. And so they are essentially saying, okay, in order to pool those leases, go ahead and compulsory pool us so that those are included. Their lessors, their mineral interest owners that they lease from will receive their normal royalty rate, even though their lessee is being compulsory pooled. And this is common. Oftentimes there's forced pooling or compulsory pooling requests that there's one working interest owner or lessee that just didn't respond or didn't want to sign a JOA, and so you have to go through this process, whether it's a mineral interest owner or a working interest owner, a lessee.
But they receive the royalty of that actual lease, not an average over the whole drilling.
Correct. If the mineral owners have leased, they just receive whatever stated in their lease.
Okay, thank you.
Okay. So that explains Exhibits 3 and 4. Now, Exhibit 5, Leslie, can you please explain what this exhibit is?
Yes, in this case, these are estates of parties that we either knew because something was of record that they were deceased, or we have since found that out. For example, the Margaret Baird, also known as Margaret Baird Jenkins estate, the title opinion came through with heirs of Margaret. And the reason for that was because in 2002, there was an affidavit of heirship filed by her husband, George Jenkins. And so we knew that she had, in fact, passed. I have her obituary here. She passed in 2000. I'm just going through this so you can understand how difficult sometimes it can be to find these heirs. She passed away in 2000. That was 17 years ago. I've tried, her obituary says she's survived by her husband, George, 7 daughters, 7 sons, 14 grandchildren, 16 great-grandchildren, and 10 great-great-grandchildren, but not one name of any of them. So it's kind of hard, and there's no probate. There was nothing filed of record. So, I start off trying to find George, obviously, and then in that affidavit, there was a discussion about a Casey R. Baird. I've tried to find him, mind you, this was 17 years ago, 15 years ago that this went of record. So I have sent multiple things out to various addresses for George and Casey, and I'm not having much luck. So I don't know how we ever get this one resolved when there's no way to find her heirs.
Exactly. So again, an example of what it takes to try and locate these and why the estates have to be included when no probate has been done, because they haven't been determined by a court. There's no final order issued. Okay, thank you, Leslie. I would now like to turn to exhibits P and Q. Will you please take a look at those, Leslie? And I will ask if those were prepared by you with input and review from AXIA personnel.
Are you
Yes,
through
they
with,
were.
Are you through with Exhibit 6? I mean, you referred to it, but you didn't. The witness didn't discuss what it is. Or are you not coming to that yet?
Exhibit 5. Exhibit 6 was a little while ago. Exhibit 6 was a description of tracks.
Oh, I'm sorry, I got backwards on that. I thought you said 5 and 6 just a minute ago.
Oh,
Excuse me.
no.
Okay.
Okay. I'm sorry, I didn't hear if you answered. Were exhibits P and Q, or really exhibits P through AG, prepared by you with input and review from AXIA personnel?
Yes,
Okay.
they were.
And can you explain exhibits P and Q, and also explain why the other exhibits that relate to this aren't all included here, and why we're not going through each one?
Sure. Exhibit P is an example of the election letter that we sent out to Lynn Energy Holdings, which is one of the working interest owners, also known as the lessee. And that's a proposal letter to Lynn, ask him, would you like to participate in the drilling of this well? Would you like to non-consent? Would you like to farm it out to us or sell your interest? So it allows the working interest owners to decide if they want to participate in the drilling of the well or not. And there is the green card showing that Lynn did in fact receive that letter from us. Exhibit Q is an example of the letter that we sent to Grant Cook. He is a mineral owner. He owns a mineral interest that is unleased. So I sent him this letter asking him, would you like to lease your land? Would you like to sell your mineral interest? Or would you like to pay your share of the cost and participate in the drilling of the lands? And again, here's the green card where he signed for this and said he'd like to sell. So I sent him a mineral deed to the same address, and it came back no such address. So again, I'm trying to work it out where I can track him down since he has agreed to sell. But this is the process that we go through with every single working interest owner, every lessee, and every mineral interest owner who has not yet leased to anyone.
And exhibits, the exhibits that were submitted relating to the green cards and the offers to lease or participated were submitted as exhibits P through AG. However, in the interest of time, so we don't go through each one, we've pulled out an example of each, an offer to participate to a working interest owner, a lessee, and an offer to lease or participate to an unleased mineral interest owner. And those are the examples that Ms. Gadd just covered. And Leslie, was AXIA willing to work with any of these owners that contacted AXIA even up through yesterday?
Oh, absolutely.
And as was already discussed, this was the case with the Wilkins heirs and their lessee, John D. Chasel, correct?
Correct.
Okay. And how were these letters sent?
I'm sorry, certified return receipt requested. We'd like, we do that on purpose so that we have some notification that the letter was even received.
Okay, thank you. And in the proposal package, were the leases and JOAs that were sent to the various owners, were those consistent with other leases AXIA has received from other mineral interest owners and consistent with other JOAs signed by other working interest owners who agreed to participate?
Yes.
Okay, thank you. Now I'd like to discuss the average landowner's royalty. As mentioned, calculations for 2 of the units have been submitted, the only ones where there are unleased mineral interests. Utah Code Annotated Section 40-6-6.5, subsection 6, provides a compulsory pool to unleased owner is entitled to payment of the average landowner's royalty during the payout period. Leslie, I'd now like you to turn to Replacement Exhibit N, which was submitted with the motion yesterday. Again, Replacement Exhibit N had to be submitted because a party agreed to lease at the last minute. And Exhibit O, and ask if these were prepared by you with input and review from AXIA personnel.
Yes.
Okay, can you explain Replacement Exhibit N and Exhibit O?
Yes. So every lease that is valid and that's been taken out there is reflected in here on these sheets. So each lease shows the lease net acres and the landowner royalty that will be paid to each one of those leases, the amount of acreage that their lease contributes to the whole, which is the result of the participation factor. And then what we do is we do a weighted royalty average calculation that will end up, I don't have it, can you show me that last page there, David? Page 2?
Yes.
Thank you. Flip down a page. So the total weighted royalty, once you take all of this into consideration for this particular well, would be a 16.03, or I'm sorry, 0.16037497 royalty, landowner royalty that we would pay any one of, say, these Wilkins heirs. If we couldn't have found them, or there's another heir, that's what they would be paid. Because we don't have a lease.
Okay. Thank you. And then Exhibit O?
Exhibit O is the same, just for a different well, where once we gather all the leases together, as you can see, there's 123 leases in this. Once you gather all the leases together and you identify the lease royalty in each lease, you do a weighted average that resulted in a 0.1685416 royalty interest that would then be paid to anyone that was forced pool, any mineral interest owner forced pooled under this order.
Thank you. Can you please address which wells Replacement Exhibit N applies to and Exhibit O?
Yes, they are. Oh, here we go. The one is the Butcher Butte 35-24H21 well, which is in, I'm sorry?
Which is in which DU?
It's in DU1, which covers sections 26 and 35 of 2 South 1 West.
Okay.
And the other one is in DU2 for the Butcher Butte 34-94H-21 well that will be located in sections 27 and 34, Township 2 South, Range 1 West.
Okay, thank you. Now, does Exhibit O contain the calculations for the Wilkins heir leases?
No, because I have yet to be furnished with the lease. Yesterday, Mr. Chasel informed me he was in the process of recording the leases now, and once he got them recorded, he would send me copies of the leases. So until I get the leases, I don't know what the lease royalty interest is that he agreed to pay them. So I can't fix this weighted average until I know what the royalty is under the lease.
So when AXIA receives copies of the recorded leases, those royalty rates and the average weighted royalty will be included in those calculations, and a replacement exhibit will have to be submitted when provided, correct?
Correct.
Okay. Okay, I'd like to turn now to discuss the joint operating agreement that was submitted and the 300% non-consent penalty. Again, Utah Code annotated section 40-6-6.5 subsection 2 sub C allows the board to adopt terms of a joint operating agreement to govern operations as between the consenting and compulsory pooled non-consenting parties. Leslie, can you please turn to Exhibit H, and I'll ask if this was prepared by you or AXIA personnel with input and review from AXIA personnel.
It was prepared by AXIA personnel. It was not prepared directly by me, no.
Okay, this was prepared by Mr. Rick Gallegos, I believe.
I believe so, yes.
Yes. But you have reviewed this exhibit and discussed it with Mr. Gallegos prior to this hearing, correct?
Correct.
Okay, can you explain this exhibit? Before you explain, I want to state that the JOA, I believe, contains close to 100 pages or more. There are a few parts that are relevant, I think, to this hearing, and so instead of going through each page of the HOA or the JOA, we'll discuss those pages, a few relevant portions. So, Leslie, can you explain this exhibit, the portions that we've included here?
Sure. This is the title page or the cover page, just stating that we're using the AAPL Form 610-1989 Model Form Operating Agreement, which is very, very standard in the industry. Pretty much everybody uses it.
Okay, and page, what's marked as page 11 of the JOA. Can you explain what this page of the JOA shows here?
Yeah, the significance of this page is what we were discussing earlier about whether or not a working interest owner elects to participate in paying for their share of the drilling costs or elects not to participate. If they elect not to participate, they're a non-consenting party. There's a penalty to non-consent, to not participate. And in this case, what we're focused on here is the 100%, 300% non-consent penalty for anyone who elects not to participate in the cost to drill and complete the well.
Okay, and of the parties, the working interest owners that have agreed to participate and have signed a JOA, what is the non-consent penalty of those JOAs?
Those JOAs are 100%, 400%, not 300% that we're requesting today.
Okay, but we are only asking, AXIA is only asking for 300%, correct?
Correct.
Okay. Let's go to the next page. Can you explain this portion of Exhibit H?
Yes, that's the COPUS that identifies accounting procedures on how AXIA will be responsible for accounting for the working interest owners on the cost to drill, complete, and operate the wells.
Okay, and Utah Code annotated section 40-6.5 sub 4 sub D sub Roman numeral 3 provides that the board may impose a reasonable interest charge for any assessed costs that are late. As Ms. Gadd mentioned, this is the accounting procedures, and then on page C5, this can you explain what is the interest rate set out here on page C5?
Yes, this COPUS, by the way, is a very standard, and everybody uses it, so it's not, no one's shocked when they get this and see this. The interest rate is a rate that's charged on outstanding items, and again, is consistent with industry norms. It's the prime rate as published in the Wall Street Journal plus 3%.
Okay, and this is the same COPUS that's attached to all the JOAs that were signed by the other working interest owners, correct?
Correct.
Okay. And then finally, we have one more page addressing the overhead charges, and those are set out at, can you please explain the rates that are set out there?
Yeah, again, this is very common for the average horizontal well drilled in this area, is that the drilling well rate is $10,000 per month and $1,000 per well per month after the well's been completed.
Okay, thank you. Are these costs and charges typical for other JOAs in the area and included in JOAs signed between AXIA and other non-operating working interest owners?
Yes.
Okay. We'll now move on to the notice portion of the testimony. Ms. Gadd, and I believe in front of you, you have the certificate of mailing, correct?
Yes.
And the certificate of mailing is a pleading that is already on file in this cause. And was this prepared by you or AXIA personnel?
Yes.
Do you recognize the names on that list?
Yes, I do.
Okay, and what are those names, or who are those names? You don't need to read each one. I'm asking were those names included?
They're included for anyone who might be subject to this forced pooling. The terms that come out under the joint operating agreement, for example, Lynn Exchange is a working interest owner or a lessee that has not yet executed a JOA, so we wanted to put them on notice that we were going to do this forced pooling, which is why they received one, as with Robert Bayless. It also would apply to someone like Grant Cook, who, again, he said he wanted to sell. I sent the mineral deed, and it comes back, bad address, so I don't know what happened with that. We have to include him because we have not actually gotten that deal finalized. So he is also in this list of people who were notified about this forced pooling hearing. Okay,
and these names were derived from title opinions prepared by Utah licensed attorneys?
Correct.
And in some cases where necessary, these names or lists were updated through a search of the county records, correct?
Yes.
Okay. Exhibit ZZZ is now up on the screen. Can you explain what this exhibit is?
These are just the green cards, the certified return receipt requested cards that we use as standard so that we have evidence that Lynn Exchange did, in fact, received this notification, as did Robert Bayless in Uintah County, and so on, for everyone that's in there.
Okay, and these were the return receipts received by AXIA as of yesterday, November 27th, 2017, yes. Correct?
Correct.
Okay. Now, as to the unlocatable parties, those for whom no valid address was shown in the title opinions, what did you do, or how were those parties noticed?
Well, initially you would get the title opinion, and based on what the title opinion has to say, we talked earlier about Margaret Baird, also known as Margaret Jenkins, that on the title opinion she was shown as heirs of, and all the research that went into trying to find any of her heirs at all, which includes things like Google search, Ancestry.com, FamilySearch.org, white pages, which is also, I call it anywho.com. You know, we're looking at state county records for any kind of probates. And we do a very extensive search trying to locate these people, if we can.
Okay, and then as to those parties that could not be located after those searches, a motion was filed with the board to provide notice by publication, and that was granted. So turning now to Exhibit YYY. Again, this is part 1 of 2. Can you explain what this exhibit is?
Yes, this is an affidavit of publication. This particular one is from the Uintah Basin Standard weekly newspaper, notifying, if anybody's looking, that we are going to have this forced pooling, and if they own an interest in any of these lands, this will give them the notification that the hearing is coming up.
Okay, thank you. Can you, let's see. Now, and again, this is part 1 of 2 from, as you mentioned, the Uintah Basin Standard, and we have not yet received the affidavit of publication from the Vernal Express, correct?
Correct.
Okay. Mr. Rogers, this concludes my examination of Ms. Gadd.
Okay, thank you. Mr. Holder, does the division have any questions for Ms. Gadd?
Yes, we do. Thank you. First of all, you have indicated that you would continue to accept leases or participation from people up till yesterday. Mr. Brett, is it Brandt or Brent Cook? You're still not sure why you haven't received response from him. The question is, how much time, or do you have a cutoff date after which you will no longer allow parties to participate that we can include in this order?
Up until basically the date the order is finalized. So again, I sent an offer letter out to Mr. Cook at that one address. He received it, sent it back saying he wanted to sell his mineral interest. So I sent him the mineral deed for him to sign, and it came back no such address. So my next step was, again, to do a internet search trying to find, is there any other address? So I have another address for him, which I just sent out recently. I have not gotten that back, so I don't know if it got to him or not. But basically, I will continue to try to find these people. The Merrill heirs I have sent, I can't even begin to tell you how many letters I've sent out to different parties. Unfortunately, they died and they had 5 children, and there's only 2 of the 5 children left alive. And so I'm trying, again, to find them. If I can find them and get them leased before the end of the pooling, absolutely, we will lease them, and we will change our weighted average exhibit to reflect that we now have those leases in place. But yeah, I don't give up easily.
I appreciate that, and it's nice to have you as a witness. Mr. Gallegos is good, but I think he relies on you, so it's nice to find the person who chases these people down. But just to be clear, then, what will be the deadline for the purposes of other parties either agreeing to participate or to lease?
Well, the board is scheduled to hear the hearing examiner's recommended findings of fact on December 6th, yes. Correct? So we would, I guess, ask that the cutoff date be before that, December 5th.
Well, I think, we couldn't go before the board and also a half hour before we get a change. I think we need to have some date to allow you to do your work and have the board review what is presented to them. So, see, that's a Wednesday. Could we say would that Monday before their work?
December 4th.
Okay, I just think it needs to be clear for the record.
Yes, for the record, correct. Yeah,
would that give you enough time?
That would, yeah.
Okay. I doubt there's going to be a lot of changes.
I don't suspect. The only one may be this Grant Cook if he responds. And
well, and just to be clear, from the division's point of view, if after the hearing you wanted to make some adjustment, we have no objection. We just think that when you say you're willing to work with people, but we don't know exactly what that means, that if someone were to come back later and say, well, I offered and they refused to allow me to participate, we would like to know when they offered, what the deadline, what the company's terms will be, so we're clear on that.
Okay, certainly. I think December 4th would be a reasonable cutoff date to be able to get everything in. I will mention that in the last compulsory pooling request that AXIA did, we filed the recommended findings of fact with certain parties, and then before the board approved those findings of fact and issued their order, another party got their lease in or agreed to lease, and so we filed an amended finding of fact. I don't remember if you recall, but I think we do need to, for the record, have a cutoff date, and then.
Well, let's set the 4th.
Okay.
December 4th, and if there is a change after that, we could always amend it.
We can address, yeah.
Okay. And then, Ms. Gadd, as to the working interest owners, there are a number listed on your exhibits. I think they're exhibits 1, 2, 3, and 4, or substitute 1 and 2, I guess. Second amended exhibit 1, I guess is the way you title it. In which you indicate that certain working interest owners either have not yet signed a JOA or not yet paid their funds. What is the AXIA's position with regard to the time that will be allowed for those working interest owners to proceed to finalize their elections?
I think that, again, would be the December 4th deadline. I mean, we'll take it right up to the last minute we can and give everybody an opportunity to step up and make their election or to negotiate a JOA with us.
Okay. And if you wouldn't mind going to Second Amended Exhibit 1, I just want to clarify some of the status. So we talked about Grant Cook.
Yes.
He's done neither, and you're trying to find him. What about
Yes.
Lynn Exchange Properties? Have they, it says on this exhibit that they have not yet tendered AFD costs and have not signed a JOA. Is that still the case?
Correct. They did elect to participate in the drilling of the well. So, every company's got a lot of things going on, the holidays. I don't know if they lost their landman or what. So it's not that I don't think we can work something out with Lynn by December 4th. I actually think we can. It's just a matter of getting both parties to the table on that.
So is the communications between you and Lynn clear enough that if you say they've got till the 4th to pay their money and sign the JOA, that's not going to take them by surprise? That's something they will understand to be fair and reasonable?
Absolutely. Absolutely. Mr. Chazell signed his JOA literally yesterday. I literally faxed it to him. He read it, signed it, and faxed back his signature. Okay. Yesterday. So, and he also has been a long time in the oil and gas industry, but he's retired. So yeah, Lynn is fully aware that they need to sign the JOA or they're going to be force pulled.
Okay. And just turning then to your other substitute exhibit, which is titled Third Amended Exhibit 2. Mm-hmm. I think the only other person there that we haven't talked about is Badlands. They have not made up their mind. Is that the situation there?
Yeah, I believe Badlands is struggling. I don't know that they have very many employees.
They're in bankruptcy,
left.
aren't
So,
they? Yeah.
I mean, it's hard sometimes to get, if there's only a few people left at a company, it's really tough to get decisions made and they don't even have people to look at it. But they're fully aware of this as well.
Okay. And then Exhibit 3. So Newfield has elected not to participate, as well as Newfield RMI. Robert Bayless have not yet tendered the AFD costs and not yet signed a JOA, and they will be bound by the 4th as a deadline for them.
Correct, and Bayless has been in the business forever. They're fully aware of force pooling and won't come as any surprise to them either.
Okay, I think then that covers everybody, that just Newfield in drilling unit 4, right?
Correct.
Would you turn to Exhibit P, please? And looking at the first letter, which is dated September 6th, 2017, first of all, let me just clarify. Were all these letters sent at least 30 days prior to this hearing?
Yes, to the working interest owners, I will say yes.
Okay. And that's what this letter is indicative of, right?
Correct, a Lynn letter, yes.
This is something that maybe Mr. Gallegos didn't communicate to you after previous hearings, but previously the division has advised the board that it feels, and I think the board itself has asked some questions about the language in the last paragraph in which you say that if we don't receive a response from you within 30 days of receipt of this letter, in this case Lynn, by default will be deemed to have elected not to participate, and as a consequence the penalties will attach, to paraphrase. In the division's opinion, that's a prerogative of the board and not something that can be deemed to have happened either by this letter indicating that they would be deemed to have elected to participate. And I think you've indicated you've had communications, and this is not an issue with Lynn, but the division would think it would be better if that letter were revised to indicate that the board may deem them to be, because it sort of goes contrary to your statement that you're willing to work with people, and yet, you know, on the other hand, but if you don't respond within 30 days, it's too late. So that's just...
I'll bring that up with Rick. I think where this comes from is it has been standard for the last 37 years that I've been in oil and gas, that the JOA, you have 30 days under a JOA to elect to participate or to not participate. So I think that was just sort of in line with what a JOA would say. Under a JOA, the operator has a right to propose the drilling of a well, and the parties to the JOA then have 30 days to elect to participate or not. So I think that's where that came from, but I can certainly talk to Rick about amending that.
In the context of a JOA, I think we agree that that makes sense because it's a contractual matter, and you as the contracting party can make that determination. But when you come to the board and ask for force pooling, that determination has to be made by the board, in our opinion.
I will definitely discuss that with Rick.
The same thing applies to the last paragraph of the next letter, which goes to the owners, mineral owners that you are unable to agree to or get leased, where it says, if AXIA does not receive response to this letter by October 5th, you will be deemed to not be elected. And of course, if the letter goes out September 12th, maybe that doesn't give them enough time and they get it late. So a more inclusive or welcoming response on that, I think, would provide fair notice to people. That's
those mineral owners are a little bit harder because finding them again doesn't always give us, I mean, I might find them a week before the hearing, and even sometimes I'll send out a letter that gives them time after the date of the hearing. So we do give them as much time as we possibly can, and there is, you know, we just set the December 4th as a cutoff date. So at some point, you know, we have to say, if we don't hear from you by this date, we have to move forward. So we'll see if we can't set that date a little further out for them.
Your testimony as to the efforts that you've made to locate certain people has indicated a lot of effort. Is that true of all of the people that you have been able to identify but not locate?
Absolutely.
All right, that's all the questions I have. Thank you.
Okay. Next witness, thank you, Ms. Gadd.
Yeah, I'd like to call Mr. Frenzel. Can you please state your name and business address for the record?
Terran Frenzel, 1805 Shea Center Drive, Highlands Ranch, Colorado.
And your current position with AXIA?
VP of Completions and Engineering.
I stated that we would delay discussing AXIA's corporate bonding status until we had one of the employees of AXIA here. So, Taryn, can you please discuss AXIA's corporate and bonding status?
AXIA is an LLC in good standing, qualified to conduct business in the state of Utah, and fully bonded with all appropriate state and Utah federal agencies relevant to this cause.
Okay, thank you. Now, Mr. Frenzel's qualifications were submitted as Exhibit A. He's previously been recognized as an expert in petroleum engineering and various spacing and compulsory pooling requests, including most recently Docket 2017-024, cause number 139-149. Has been previous practice.
We would, no objection.
Okay, thank you.
Recognize him as an expert witness.
Yeah, yes, we'd like him admitted as an expert witness in petroleum engineering for purposes of this cause. Taryn, can you please turn to exhibits I, J, K, L, and M? You have those in front of you, correct?
Yes.
Were these prepared by you or AXIA personnel with your input and review?
Yes.
Okay, thank you. Let me get to those exhibits. Okay, we'll go first to Exhibit I. Can you please explain Exhibit I?
Yes, this is the AFE that explains the cost for a well in 2 South 1 West, sections 26 and 35. This is a Uintah well, summing $10.7 million.
Okay, and this is in the DU-1, correct?
I don't have the DUs.
Okay.
Over there.
I can help you.
Yeah.
Which one was it?
It's section 26 and 35.
26 and 35 is right. 2-1? So it's DU1.
DU1, yes.
Okay. And the second page of Exhibit I, can you explain this page of the exhibit?
Yes, this is the cost to plug an abandoned well and reclaim the location.
Okay. And Exhibit J?
Exhibit J is the second well on this pad. It's for a Wasatch 4 well in 2 South 1 West, sections 27 and 34, amounting to approximately $10.7 million as well.
Okay, and sections, to clarify, sections 27 and 34 of 2 South 1 West is in DU-2.
Correct.
And the second page of Exhibit J?
Second page is, again, the plug and abandon costs and reclamation.
For that well, correct?
That well, yes.
Okay, moving on to Exhibit K.
Exhibit K is one of a 3-well pad, Township 2 South, 2 West, sections 26 and 35. This is the card marker. $10.56 million is the AFE.
Okay, and for clarification, this section in Township is in DU-3.
That's correct.
And the second page of Exhibit K?
This is the plug and abandon cost to for the well and reclamation of the pad.
Okay, and Exhibit L also in DU-3, the second well in DU-3. You explain this exhibit?
This is in, again, 2 South, 2 West, sections 26 and 35. This is the Wasatch 4 well. These are all the costs of drilling and completions, amounting to $10.7 million.
And the second page of Exhibit L.
Again, the costs associated with plugging and abandoning and reclamation of the pad.
Okay, and finally, in DU-4, Exhibit M.
This is in section, or 2 South, 2 West, sections 27 and 34. This is a Uintah well, drilling and completion costs amounting to $10.6 million.
And the final page of Exhibit M.
The plug and abandon costs and reclaiming the pad.
Okay, thank you. In your expert opinion, are the costs fair, reasonable, and necessary?
Yes.
Okay. I'd now like to discuss the risks associated with these wells. Can you, in general terms, discuss the risks involved with these 5 wells that are involved in this cause?
Sure. These are long laterals, 2-mile laterals. They take 25 to 30 days to drill, very high pressures. So with any environment like that, any small problem is into a large risk.
Okay, then in your expert opinion, especially when considering the amount of risk involved and the other reasons that have been previously outlined in this hearing, is a 300% non-consent penalty justified?
Yes.
Okay. Mr. Rogers, this concludes my examination of Mr. Frenzel.
Thank you. Mr. Alder, do you have any questions for Mr. Frenzel?
Yeah, Mr. Doucette has a couple for him, if you don't mind.
So you mentioned on these risk on these wells being basically drilling completion risks. Is there any other risks involved as far as the hydrocarbon being present or the amount of hydrocarbon present?
As you know, this is a few of these wells, Uintah and Butte, the Wasatch Core, have been drilled before. We feel like there's very little risk in the hydrocarbon or the amount of hydrocarbon. We have a good working model on that. However, the card marker will be an exploratory zone. So the amount of hydrocarbon, we know there's hydrocarbon there, but the amount of hydrocarbon would be a secondary risk for sure.
Okay. Is there any other risks involved with these wells?
No.
And I think the testimony earlier was that 3 of the wells had been just, the surface casing had been spud. I guess surface casing had been set. When do you, is it currently, any of these currently drilling, and when do you expect them to be all drilled and completed?
Exhibits, I, J, and K, 2 of the wells have been drilled completely. We're on the 3rd well on that pad and should take another 10 days or so to be completed, which is actually Exhibit J, that well. Completions to happen January 1st-ish on all 3.
And then the other two,
the drilling rig, as soon as they're done in a week, we'll move over and spud those 2 wells.
Okay, thank you.
That's all the questions the division has.
Mr. Bolden.
At this time, I move for admission of the exhibits.
Mr. Chairman, or Mr. Rogers, I apologize. I did have one question for Ms. Gadd that I forgot to ask. If you're ready to summarize, before you summarize, and
okay, yes, that's fine.
With regard to the BLM ownership in drilling unit 1, when you calculated the royalty, it wasn't clear. I think the tracks indicate partial fee, partial BLM. Did you include the BLM in those tracks, royalties in those calculations or not?
For the weighted average
Yes.
landowner royalty? No, I did not. There were no BLM or state leases or county leases or any of that were included. Those were just fee leases that were included in the weighted average royalty calculations.
Thank you. I just wanted to clarify if that was the case. Thank you.
Back to you, Mr. Bolton.
Okay. I'll just, in conclusion, state that I believe that the testimony and the exhibits presented show that the statutory and regulatory requirements have been satisfied, that the requested relief is fair, reasonable, and justified, and ask that it be adopted. And then, again, at some point we need to move for admission of the exhibits. We can do that now if you'd like, or if there's going to be additional. I don't know if the division has prepared any testimony or presentation.
No, the division will present no witnesses or testimony. We support the request, and someday we'll figure out how to do this a little faster. Apologize for the time it's taken. I'm sure we can, as you have 32 wells per drilling unit, by the end of the last well, we'll do it.
Figured out.
Do it quicker. But anyway, no, if you want to introduce offer the exhibits.
Yeah.
Would be appropriate.
Do that at this time then?
Yeah. I'll read you what I've got, and then if you feel like we were missing something, you can let me know. So I would move for admission of Second Amended Exhibit 1, Third Amended Exhibit 2, Exhibits 3 through 9 to the request, Exhibits A through M, Replacement Exhibit N, Exhibit O, Exhibits P through V, Exhibit W, Exhibit X through AG, Exhibit YYY Part 1 of 2. Part 2 of 2 will have to be submitted when we receive that, and then Exhibit ZZZ. That's what I've got.
Just exactly what I had.
Keeping track, thank you.
No objection.
As supplemented.
Okay, Julianne, we're okay there? Okay, thank you.
Okay.
Anything else, Mr. Bolden?
No, that is all.
Okay. My counsel would like to address a few things at this time.
These are just items that I was going to note should be included. The December 4th deadline, and that you'll be filing new exhibits as needed if more people lease or participate. That the vernal affidavit of publication is still outlying, so we'll just be waiting on that. And then a couple points of clarification. I think just being clear on that we're pooling wells rather than pooling units, I think was a little bit unclear for us when we went through the request. And last, just clarifying that the term working interest owner, just that question that Ms. Gadd covered for us, if that could just be clarified in the order, the role that those people are playing, so that they're not really a working interest owner with respect to this particular well, or just kind of being more clear on like the role that those parties are playing.
I'm not sure I understand the question.
I think the term working interest, pulling working interest owner is like a little confusing to us. If we just call them leasee.
Do you know what I'm trying to say?
Well, but it's a defined term, and it means, in the statute, it means the person who's entitled to production, and in some instances, if it's, I think the confusion was that in one instance, it suggested that all the people were leased, and the assumption was, I think, in the context of the request for agency action, that it assumed they were leased to AXIA, but in fact, if they're leased to other parties, they then can still be non-participating in the well, and maybe that's the clarification that.
And they still can be force pulled. They're not
and therefore
leased
they need to be force pulled.
They're leased to someone else,
right,
but they're not.
So.
But those mineral interest owners are not being force pooled. It's only that the working interest owner, I think, is a clearly defined term, and it's a lessee, which means they've taken leases from other from mineral interest owners. So I'm not sure what sort of clarification I could do there. Working interest owner is, again, like I said, the lessee, and if they have not voluntarily committed their interest into a drilling and spacing unit, then they have to be compulsory pooled, and it's a common occurrence where a working. So there may be something that wasn't clear in the request that caused that confusion. And so I'm trying to understand what needs to be done differently to clarify.
Well, my confusion was when I read it, it says all parties leased. And I go, okay, great, everything's fine. And then in the next sentence it says, but there will be working interest owners to be force pulled. So they really aren't all leased. They're leased, but not necessarily to you.
No, they're all leased, but they're not all committed.
Yeah, and
they have not all voluntarily committed their interest. The working interest owner.
It's a little confusing to me as I read it. Yeah.
So maybe
if you would submit, excuse me.
Go ahead.
I was going to suggest we will probably see the proposed findings of fact, and if there's any confusion, we can communicate that with Mr. Bolda and make sure everybody's happy about
Okay.
it.
I think after this process, I understood it better, but reading through it, I was a little confused. I mean, that.
Okay.
Okay. Anything else, Meg?
No.
Okay. I don't know if we need to point out, because we have not yet received an order from the board allowing granting leave. Okay. These could be admitted pending approval from the board.
Sure.
The board has granted the order allowing those exhibits,
Okay.
provided there are no objections.
Okay.
And the division does not object.
And
No objection.
can I confirm that the exhibits have been admitted? Did you?
Yes. Yes. We accept those then. Thank you.
I think it was with Meg. So
Oh, yeah.
Meg was.
Were you, anything else? Okay. Well, thank you. Upon the presentation of this evidence and my evaluation of it, I see no reason not to support this as a hearing officer, this proposed matter of force pulling. I would like to stress it again, that the December 4th deadline, we'd like to get that in there, and I would urge AXIA to take advantage of these next few days to get as many people on board as you can, especially those that you've had some communication with, like Mr. was it Cook and those other individuals. Just give it one more shot if you can.
Absolutely.
And again, the 300% penalty, we agree to that. So I think all statutory, regulatory statutes have been met. And so, Mr. Bolda, could you prepare an order for a presentation before the board at the next December 6th hearing?
I will do that.
Okay.
Yes.
Anything else?
No, Ms. Gadd, it was nice to meet you, and
Yes, nice to meet you too.
you should come to Salt Lake sometime.
I have a friend that lives there. I'll be there shortly.
Thank you.
Okay, and thank you. I thought this went very well. Thank you to Paul and Tom for getting this set up on the video conferencing. It was very impressive today. So thank you. At that point, we'll conclude the hearing.
Okay, thank you. Thanks, guys.
Thanks.